Tonight, the Supreme Court has delivered a landmark 9-0 decision, a moment that will be remembered for years to come. In a city where division and partisanship often dominate the headlines, this rare moment of complete agreement among the justices has sent a powerful message across the nation. The news has sent shockwaves through Washington and the entire country, reverberating from the halls of Congress to living rooms in every state. Politicians, legal scholars, and everyday Americans are all grappling with the magnitude of what has just happened. In a rare and striking show of unity, all 9 justices, liberal and conservative alike, stood together to declare that digital privacy is not just a privilege, but a fundamental right protected by the Constitution. This historic ruling draws a bold and unmistakable line between the powers of government surveillance and the rights of individuals in our increasingly digital world. It's a decision that acknowledges how technology has transformed our lives and how the law must evolve to keep pace. Legal experts are already calling it one of the most significant Supreme Court decisions of the decade, if not the century. They say it will set a precedent for countless cases to come, shaping the boundaries of privacy and government power for generations. The court's message is clear and resounding. Some rights are so essential, so deeply woven into the fabric of our democracy, that they transcend politics, ideology, and the shifting winds of public opinion. The decision redefines what it means to be secure in our digital lives, recognizing that our emails, texts, and online activities deserve the same protection as the papers and effects in our homes. Tonight, the air in Washington is thick with analysis and debate. What does this mean for law enforcement, for technology companies, for the millions of Americans who live so much of their lives online? The questions are urgent, and the answers will shape the future. The court declared, in no uncertain terms, that your digital footprint, everything from your search history to your location data, deserves the same constitutional protection as your physical home. This is a dramatic expansion of privacy rights in the digital era. This isn't a minor tweak to existing law. It's a legal earthquake, a seismic shift that will reshape American law and society for generations to come. The headlines tonight reflect the gravity of this moment. In the coming minutes, we'll break down what this means for you, the landmark case that brought us to this point, and why a unanimous ruling from the highest court in the land carries such extraordinary weight. The implications are vast, touching everything from how police conduct investigations, to the way tech companies collect, store, and share your personal data. Every sector of society will feel the impact. This is more than just a legal story, it's a turning point in the ongoing debate about the future of privacy in America. It's about how we define freedom and security in a world where technology is everywhere. Stay with us as we unpack this monumental Supreme Court ruling, exploring its far-reaching consequences and what it means for you and your family. The decision's impact will be felt in every corner of American life, from classrooms and workplaces to homes and businesses. No one is untouched by this new understanding of digital privacy. Tonight, we begin our deep dive into how your rights have changed, what protections you now have, and what this means for the future. Let's dive in and explore this historic moment together. At the heart of this landmark Supreme Court ruling is the case of United States versus Digital Privacy Alliance, a pivotal moment in the ongoing battle over digital privacy rights in America. The case began when law enforcement agencies, using advanced surveillance technology, collected vast amounts of digital data from entire communities, without obtaining individual warrants for each person. This included tracking people's locations, monitoring their online searches, and even accessing private emails, all in the name of public safety. The government argued that such sweeping data collection was essential for national security, comparing it to observing public behavior in a town square, but on a much larger digital scale. Officials insisted that these measures were necessary to prevent crime and terrorism in an increasingly connected world. But the Digital Privacy Alliance, a coalition of privacy advocates and civil liberties groups, strongly disagreed. They argued that this kind of mass surveillance violated the Fourth Amendment, which protects Americans from unreasonable searches and seizures by the government. The Alliance insisted that our digital lives, our emails, our locations, our search histories, are just as private and sensitive as the physical papers and effects the Constitution was written to protect. In today's world, so much of our personal information exists online, making digital privacy more important than ever. As the case moved through the courts, judges across the country were divided. Some sided with law enforcement, emphasizing the need for security, while others warned that unchecked surveillance could have a chilling effect on free speech and personal freedom, undermining the very values the Constitution was meant to uphold. Ultimately, the Supreme Court was faced with a crucial question: does the Fourth Amendment's protection against unreasonable searches extend to the mass collection of digital data, even when done in the name of national security? In a historic decision, the court answered with a resounding yes. The justices ruled that digital data is indeed protected by the Constitution, and that mass, warrantless collection of personal information is unconstitutional. This ruling sends a clear message. In the digital age, Americans' privacy rights remain a fundamental part of our democracy. The Supreme Court affirmed that our personal data cannot be freely collected or searched without proper legal oversight. The debate is now settled. Your digital data is not fair game. The Constitution protects your privacy, both offline and online, ensuring your rights are upheld in the modern world. A 9-0 Supreme Court ruling is rare, especially on such a divisive issue. Unanimity gives the decision immense authority. It's not about politics but principle. All justices agreed. Fourth Amendment protections must evolve with technology. This sends a clear signal to lower courts, Congress, and the executive branch. There's no ambiguity. Lawmakers must now respect this new boundary of digital privacy. The ruling strengthens the court's legitimacy, showing unity in defense of core rights. It assures Americans that digital privacy is not a fleeting concept, but a constitutional guarantee. The power of 9 justices united brings certainty to the law. This is a rare moment of clarity in a divided era. The Supreme Court's landmark decision has instantly rewritten the rules for federal law enforcement agencies across the country. This ruling is not just a minor adjustment, it's a sweeping change that impacts how investigations are conducted at the highest levels. Agencies, like the FBI and NSA, which once relied on broad, warrantless data collection programs, must now immediately halt these practices. They can no longer gather massive amounts of digital information from Americans without oversight. From now on, if federal agents want access to your emails, cloud storage, or social media accounts, they must first convince a judge that there is probable cause. Only then can they obtain a specific warrant targeting particular digital accounts or devices. This new precedent doesn't stop at the federal level. State and local police departments are equally bound by these constitutional protections, fundamentally changing how they conduct digital investigations. Sweeping up cell phone or social media data from entire neighborhoods, or conducting dragnet surveillance without individualized warrants, is now clearly unconstitutional. Law enforcement must respect the privacy of every citizen. As a result, states are now required to review and rewrite their existing laws to ensure they comply with this new standard. Legislators and legal teams must work quickly to update policies and procedures. Congress, too, faces the challenge of crafting new federal surveillance laws that fit within these constitutional boundaries, ensuring that national security efforts do not violate individual rights. The Supreme Court's decision now sets a single, uniform national standard for digital privacy, replacing a patchwork of state laws and inconsistent protections. Looking ahead, this precedent will shape how courts handle future cases involving facial recognition, artificial intelligence, and other emerging surveillance technologies. The legal landscape for digital rights is forever changed. The message is clear. As technology evolves and becomes more integrated into our daily lives, so too must our rights and legal protections adapt to keep pace. Thanks to this ruling, the Fourth Amendment now firmly and explicitly protects your digital life, ensuring your personal information is shielded from unreasonable searches and government overreach. For tech companies, this ruling is a game changer. They now have legal grounds to demand specific warrants before handing over user data, expect updates to privacy policies, and more investment in data security. For consumers, this means greater trust. Your private information is better shielded from government overreach. Businesses that champion privacy will stand out. For individuals, your emails, messages, and location data are now constitutionally protected. Law enforcement can still investigate, but only with a warrant. This ruling doesn't affect how companies use your data for business, but it draws a clear line for government access. The balance of power shifts. Your digital life is now guarded by the Constitution. It's a new era for privacy in America. Think about your smartphone. It tracks your location, holds your conversations, and stores your searches. Before, law enforcement could collect neighborhood-wide data without individual warrants. Now that's illegal. Your emails and messages are now as protected as letters in your home. To access your digital life, police need a specific warrant, just like they would to search your house. Your search history, revealing your private thoughts, is now off limits to broad government sweeps. Investigators must target individuals, not entire communities. This ruling empowers you to expect privacy online. Living in a connected world no longer means surrendering your rights. The court has affirmed, your digital life deserves real protection. This is a practical, tangible shift in how your data is treated. Your personal information stays personal. This unanimous decision is a turning point for American law and society. The court has shown that our founding principles adapt to the digital age. This ruling will guide all future debates over technology and privacy. It reframes privacy as essential to freedom, not a barrier to security. Congress and the White House must now innovate within these constitutional boundaries. The decision may spark a new culture of privacy awareness and inspire future leaders. Privacy is vital for free expression and democracy. This story began with citizens and advocates demanding change. The court has spoken, but protecting these rights is up to all of us. Stay informed, hold leaders accountable, and defend your digital freedom. The future of liberty depends on your engagement.